Okay, Mr. Murillo, are we live?
Yes, we are live.
Okay, and is it open up to the community members now?
Yes.
Okay, excellent. Well, good evening, everyone. We welcome you tonight to our forum on use of force. We have a relatively robust use of force policy here in the city of Berkeley, and we'll be going over it. We are the Office of Director of Police Accountability. We'll be doing more formal introduction soon. My name is Hansel Aguilar. I am the Director of Police Accountability. And tonight's topic is on de-escalation and proportionality as it relates to use of force. This forum is part of our ongoing efforts to promote transparency and accountability within the Berkeley Police Department. We're here to have an important discussion on the role of de-escalation tactics and the proportional use of force in policing. So we appreciate you all being here tonight and being part of this crucial conversation. If you aren't able to make it here tonight, this will be recorded, so you may be viewing it after the fact, and we appreciate any comments and feedback you can provide to our office. Please note that the use of force policy within the city of Berkeley requires a joint review by the Police Accountability Board, which we'll tell you a little bit about shortly. So these conversations we're having tonight is to help us guide the Police Accountability Board and the police department in those conversations that they'll be having later in the year. Here's our agenda for tonight. We're going to be doing some staff introductions. We're going to be doing an overview of the Office of Director of Police Accountability and the Police Accountability Board. We'll do an overview on the use of force policy. We're going to be able to take it from the abstract and apply it to a real case. So we'll be doing an incident review. We do provide the forewarning to community members that use of force is not a light topic, and there will be some graphic content shown tonight through this forum. So we provide you that advisement. We'll let you know when we'll review the video. If you want to step away, we understand. The reason why we're showing a video is to be able to have a discussion about an incident that police can have between between a police department and a member of the community, and see how force is applied and go through the policy to see what are the considerations. And although it's not an incident that happened within our community, it's still an incident that allows an opportunity for us to have a conversation about use of force in general. We will then have some reflections on that incident, and we'll open it up to public comments, and then we'll finish off with our closing remarks. So about us, again, this forum tonight is being hosted by us, the Office of Director of Police Accountability, but we also want to acknowledge our Police Accountability Board members, which are appointed by our City Council. We are currently, the Police Accountability Board is being led by Mr. John Moore, who's the chair, Ms. Leah Wilson is the vice chair, Kitty Calavita, board member Kitty Calavita, Julie Leftwich, board member David Williams, board member Brent Blackaby, board member Josh Cayetano, and board member Alex Moses. That is your Police Accountability Board. And now for our Office of Director of Police Accountability, which is the other component of our civilian oversight system in the city. I am currently leading the office as your Director of Police Accountability. It is my role here in the office to make sure that we're providing complete, thorough investigations of the allegations of police misconduct, and that we're providing these reports to our Police Accountability Board, who will then make recommendations to the Chief of Police, and also supporting our Police Accountability Board when they're conducting their policy review, which we'll hear about shortly. I want to provide to you there, you can see the list of our staff members. Mr. Jason Wechter is our investigator. He's unavailable tonight, but I'll hand it off to Mr. Keegan Horton, who will be introducing himself.
Investigator Horton, you're muted.
Sorry about that. Good evening. My name's Keegan Horton. and I serve as an investigator with the Office of the Director of Police Accountability. In my capacity, I work diligently to examine complaints and ensure that all findings are based on thorough and objective investigation. My goal is to help maintain the integrity and accountability of law enforcement in Berkeley. Later on, I'll provide more information about our complaint process, and I'm excited to share that information and more about our work as it relates to the process to use of force policies today. I'll now pass it on to our policy analyst, Jose Murillo.
Good evening, everyone. I'm Jose Murillo, policy analyst for the Office of the Director of Police Accountability. My role involves reviewing and analyzing police policies and practices to ensure they reflect community expectations and align with best practices in the field. I also support the Police Accountability Board in making informed policy recommendations, and I'm looking forward to discussing the policy implications of use of force and de-escalation tactics during today's forum. I'll now pass it on to my colleague, Melanie E. Beasley, our administrative analyst.
Good evening. My name is Melanie E. Beasley, and I'm the administrative analyst for the Office of the Director of Police Accountability. My role includes managing the administrative functions that support our offices and the board's operations from record keeping to facilitating communication between the public and our team. I also assist in organizing public forums like this one to ensure they run smoothly and effectively. I'm pleased to be a part of today's important conversation on use of force, and I look forward to your participation. And now back to our director, Hansel Aguilar.
Thank you. I want to just give a special recognition for somebody from our team who's not present today, and she fulfilled her mandate this summer. Our summer intern, Chloe Park. She is a Cal senior, and we have her to thank for a lot of the coordination and the behind the scenes work that went into developing these forums. She provides some pivotal feedback that we have incorporated. So we really appreciate the work that's being done in our partnership with the university. And we appreciate you, Chloe Park. Another member of our team who I'll be introducing, and we're proud to make sure that we promote in our community. We do have a therapy animal. His name is Lucky. We're innovative in our field of civilian oversight. We are the first agency, believed to be the first agency with a therapy animal program. And that is our commitment to our community's well-being and our staff's well-being, to making sure that we are providing the support to do the important work and the difficult work that we sometimes engage in. I want to not assume that all our community members have a background, or whoever's tuning in has a background on our civilian oversight system here in the city of Berkeley. So I'll give a gentle overview. As you see on the screen, we are 50 years plus of civilian oversight. I'm not going to dive deep into that 50-year history, but it is important to recognize that we have a long history of civilian oversight and community engagement with police accountability matters. So in April 17, 1973, the Police Review Commission, which was our predecessor agency, was established, and they had the mandate of being one of the first, if not the first, investigative civilian oversight agency in the country. And they have, and the city has been in the forefront of these issues through a ballot measure a few years ago. We were able to modify our civilian oversight system to establish what is now this hybrid system of the Police Accountability Board and the Office of Director of Police Accountability. So our longstanding tradition of oversight is something that we take pride in, and it continues to be a vital part of maintaining public trust in our police department. I'm going to now turn it over again to our policy analyst, Mr. Murillo, who will give you a little bit more information about what's in our city charter as it relates to our purpose and providing civilian oversight of law enforcement.
Thank you, Director Aguilar. As the director mentioned, the Police Accountability Board and the Office of the Director of Police Accountability came about as a result of Measure II, which amended the Berkeley City Charter. Through that amendment, Charter Section 125 was established, which ultimately established these two divisions, the Police Accountability Board and the Office of the Director of Police Accountability. The purpose of the Police Accountability Board per Charter Section 125.1 is to promote public trust through independent civilian oversight of the Berkeley Police Department, facilitate community participation in setting and reviewing police policies, practices, and procedures, and provide prompt, impartial, and fair investigations of public complaints against sworn police employees, which would be sworn officers in our case. The Office of the Director of Police Accountability Board, of Police Accountability, in support of the Police Accountability Board, investigates complaints against sworn Berkeley PD officers, provides independent findings and recommends corrective actions where necessary, and may serve as a secretary to the Police Accountability Board and assist them in their day-to-day duties, such as their policy reviews, and again, providing them with recommendations on personnel complaints. Next slide, please. This is just a general overview of some of the powers to the board. The charter does grant the Police Accountability Board in our office a wider range of different powers. These are just some of the ones that we're covering today. The first revolves around policy and its oversight function of the Berkeley Police Department. One of the roles and the powers of the board is to advise and recommend on the operation of the BPD, including all policies, practices, and procedures. That's section 125.3A1 of the Berkeley City Charter. Another is to recommend to City Council the approval of agreements and policies regarding mutual aids, or MOUs, as you might hear the board reference them, information sharing with other agencies, and cooperation with other law enforcement and security agencies. For your reference, that's Berkeley Charter Section 125.3A2. And in terms of, again, the complaint review and disciplinary recommendations that I mentioned earlier, one of the powers of the board is to consider the findings from the Director of Police Accountability on complaints against sworn police employees and recommend appropriate disciplinary actions where warranted. And that would be the Berkeley City Charter Section 125.3A3. Next slide, please. Next slide, please. Okay.
So again, my name is Keegan Horton, and I'm one of our investigators here. My primary role then is to investigate personnel complaints. So personnel complaints are complaints made by members of the public that allege sworn members of the BPD engaged in misconduct. Sorry for resetting the slides there. Complaints have to allege misconduct on their face, or in other words, the complaint narrative has to show a sworn BPD officer may have violated BPD policy. If the complaint meets that standard, an investigator would then review any evidence submitted and conduct interviews and complete an investigation. Investigators review this evidence at the standard of preponderance of the evidence. The preponderance of the evidence is a review that basically means more likely than not, or above a 50-50 chance that happened. In summary, when a complainant makes an allegation of misconduct, we review the evidence to see if it is more likely than not that the misconduct occurred. I'll now pass it back to policy analyst Jose Murillo, who will walk you through our policy complaint process, which is a little different.
Thank you. As Director mentioned, as Investigator Horton mentioned, the policy complaint process is a little different than the personnel complaints. Through the policy complaint process, the board has the power to review BPD policies, practices, and procedures. Community members can file a policy complaint form through our office where they believe a policy, practice, or procedure is insufficient or improper. The Office of the Director of Police Accountability accepts and receives those complaints, and we present them to the Police Accountability Board for their consideration. Once they're presented to the board has the option to either take on the policy review as a board in its entirety, establish a subcommittee, or assign it back to our office to conduct the initial research and review before they present the recommendations to the relevant stakeholders, which in this case is the City Council, the Berkeley Police Department, and the City Manager. Next slide, please. Now, our office recently adopted a new case management software called Civil. Civil is a software for managing complaints and compliments designed to improve records management and ensure a transparent and accessible process for the community. So beyond the traditional paper and pen forms that our office and our predecessor had historically accepted, community members now have the option to file their personnel complaints, their policy complaints, any contestations to the internal affairs findings, or even a commendation online, whether that be through a mobile device or web page or so forth. Civil enables our community members, again, to submit complaints and compliments about their interactions with sworn police employees directly with our office. It allows them to request independent internal affairs reviews of the findings, as well as provide recommendations to improve the services of our office, the board, and the BPD, as well as to track the status of their complaints and review requests as they are processed by the board in our office, as well as access data on past complaints, including submission numbers, the types of complaints, and the disciplinary outcomes of those complaints. And I'll pass it back to Director Aguilar.
Thank you, Ms. Murillo. And I was actually informed, and I apologize that my camera wasn't on initially in my remarks, but now you get to see the face that goes along with the voice. Now let's talk a little bit more about our use of force here. We are going to, again, ground ourselves into what the state law, what the federal case law, what the police department policy, the data suggests, and also what the actual policy within the department says about use of force. One of the importance, the laws that came, that was recently modified use of force standards in California was done through passage of AB 392. So California's use of force standards have evolved significantly with the passage of AB 392, which established that deadly force can only be used when it's necessary to defend human life. And this is embedded in our sanctity of life principles that we see in use of force policy, and specifically even in our Berkeley Police Department policy. We'll touch on a key legal precedent, again, Graham v. Connor. It was a Supreme Court ruling. We'll watch a video on that goes over that incident and what the Supreme Court said about the appropriate use of force. And these links are available to you if you want to review them again. These are some helpful resources. But Mr. Murillo, if you can queue up the first video, I'll go ahead and stop sharing my screen so you can prep up to provide that initial AB 392 overview so we can hear what the new state law requires.
Okay. So here is the video.
On August 19, 2019, Assembly Bill 392 was signed into law. Aware of the impending revisions to law, California Post gathered a small group of staff and district attorneys to review the legal changes, answer questions, provide insight, and assess how the use of force standard may be shifting. The following short informational video steps through the new language in the law and provides analysis of how it might affect law enforcement and the way they will view use of force cases. Assembly Bill 392 effectively moves the use of force requirement from Penal Code 196 to Penal Code 835A. This program will walk through each new subsection of 835A in the Penal Code and highlight meaningful changes that become law on January 1st, 2020.
Our intent is to educate California law enforcement on the new use of force standard that is recently been signed into law and will be utilized throughout the state of California, to make sure that officers are confident in what that law says and comfortable with it. We want them to apply the law, apply it safely for themselves so that they're safe. We want the communities to be safe, and we want to just alleviate as many concerns as possible as early as possible.
Prior to alleviating them, concerns first need to be identified, understood, and then addressed. At the conclusion of the meeting, each district attorney sat for a one-on-one interview to provide their professional advice on the new law. At times, they gave examples and follow those with their opinions as to the legality of using deadly force. If the facts were changed, even slightly, their legal analysis would be different.
I think that the legislature, with this law, is trying to codify an emphasis that's been happening in law enforcement towards de-escalation and the use of less lethal force.
To begin, the first 4 subdivisions of subsection A of 835A make several declarations regarding the gravity, perspective, evaluation of, and alternatives to use of force. The 5th and final subdivision of subsection A stands out for the first 4 in that it centers on individuals with disabilities and their encounters with peace officers. The law's focus on this raises the question, what has the law changed with regard to those who have disabilities?
It just points out something every law enforcement officer knows, which is people with disability are going to be in these situations and respond differently than someone without those disabilities. So they may not comprehend what's going on as carefully, and they may not be able to respond as they would want to.
Police officers know that they have to deal with the mentally ill, and it's fraught with peril. It is. Because sometimes the mentally ill don't understand their situation and they present a danger to police officers, a danger that could result in loss of life to the officer or someone else, that those officers have to deal with immediately.
The circumstances allowing for a peace officer's use of force contained in subsection B existed previously in 835A, with the exception of the insertion of one additional word. What does the addition of this word mean?
They added the word objectively to the term objectively reasonable. Prior to this, the law just said reasonable.
And that might seem like a small nuance, but essentially what it does is it creates an objective third-person standard.
But California law enforcement officers have long been using the objectively reasonable standard. That's a standard in Graham versus Connor, and that's the federal standard, and that's what they were all raised with.
It injects common sense into the decision-making process. So what would a objectively reasonable police officer do in that situation, given the same set of facts?
Subsection C focuses on the use of deadly force specifically and reads in part, a peace officer is justified in using deadly force only when the officer reasonably believes, based on the totality of the circumstances, that such force is necessary for either of the following reasons. A, to defend against an imminent threat of death or serious bodily injury to the officer or to another person. In this section, understanding the meaning of the term imminent is critical, and the legal definition can be found in subsection E.
When the person has the present ability, opportunity, and apparent intent to immediately cause death or serious bodily injury. So all of those things. And I'll say them again. When a person has the present ability, the opportunity, and apparent intent to immediately cause great bodily injury or death. So there are a couple of key words there. How does it appear, and must it be immediately confronted?
Section B addresses when deadly force may be used to apprehend fleeing felons. Officers may ask, what conditions are required in order for deadly force to be justifiable when apprehending a fleeing person for a felony?
It must be for a felony that threatened or resulted in death or serious bodily injury, and the officer must reasonably believe that the person will cause death or serious bodily injury to another unless immediately apprehended. Additionally, when feasible, a peace officer shall, prior to the use of force, make reasonable efforts to identify themselves as a peace officer and to warn the deadly force may be used unless the officer has objectively reasonable grounds to believe the person is aware of those facts.
I think in the vast majority of cases it's going to be apparent. You know, police officers wear uniforms, badge. So I think most of the time, unless you're talking about an officer that's undercover and really kind of a very specific situation. It's saying that the person should know that you're a police officer and that you're about to use deadly force if it's not obvious from the circumstances.
Subdivision 2 of subsection C is a note in that it specifically points out the circumstances when officers shall not use deadly force.
When the danger is just to the subject only, the officer believes the subject does not pose an imminent threat of death or serious bodily injury to the peace officer or another person. An example of when the only person that could experience death or serious bodily injury would be in a situation something like this. Somebody's in their own home, they're the only person in the home, and they have a knife and they're threatening to kill themselves. Law enforcement officers are outside surrounding all the exits and entrances into the house, and so the only person threatened is the person themselves. That would be an example of when deadly force wouldn't be appropriate.
In judging these situations, the term objectively reasonable officer found in this subdivision is key to understanding the type of standard officers face when making decisions regarding using force.
First of all, there's the average reasonable person, and the average reasonable person is deemed to have X number of experiences and knowledge. You up the standard when you say the average reasonable law enforcement officer because you assume that they've had training and experience as law enforcement officers. So when we're talking about a reasonable law enforcement officer, it is not that particular officer in that situation. That would be subjective versus objective.
It's still a very practical, common sense standard that we're going to be using to look at these cases. And I should say that's the change I think that's been among the most important.
The introduction of this new law may create questions regarding whether there are now scenarios where officers must retreat. Subsection D of 835A addresses this with language that should dispel concerns of officers who may think they are now obligated to retreat in certain situations.
The bottom line that if an officer has to decide, oh, when do I have to retreat or not, I think it becomes an officer safety issue. And so why do we want to put that officer in harm's way when from the beginning they need to know you don't have to retreat?
They don't have a duty to retreat. They have to confront that danger. That doesn't change.
Key to becoming educated on all aspects of this law is the comprehension of specific terms that are used throughout. Subsection E contains definitions for several important terms. The deadly force definition is one that relies on an understanding of the concept of substantial risk.
Introducing the word substantial just sort of raises the level of risk that's required. Substantial is greater than regular risk, and that's the best I can do in defining it. When you're making these decisions, you've got to be confronted with the substantial likelihood or substantial threat that someone's going to be hurt.
The totality of the circumstances is a relatively simple but often overlooked concept. It is one that is both employed by officers in their contacts and by DAs in their reviews.
It's a great term, and it's a human term. And what it tells a district attorney and what it tells a law enforcement officer is taking everything into consideration, given everything in that situation that you are aware of at that time.
That means all the facts known to the officer, all the facts surrounding the situation, everything leading up to it, and every single fact that the officer was confronted with at that moment. We're going to take all that into consideration.
The second part of the definition of totality of the circumstances refers to the officer and subject conduct prior to the use of deadly force. This may raise questions regarding how long prior to the use of force is the conduct considered.
The way I interpret that, the conduct of the officer, is how the officer is conducting themselves during that event.
We're going to look at everything that the suspect did leading up to the use of deadly force. But we're also going to look at everything the officer did. One of the things that I do when I look at these cases is I want to know what dispatch said to the officer as the officer is approaching the scene, right? So to me that takes into account what the officer knows, what the officer says, what the officer did leading up to this encounter that led to someone's death.
The only time I would add on to that would be if the suspect or the subject has had an encounter with this law enforcement officer in the past, and therefore that subject, that suspect, may be considering that as well. In most cases, law enforcement officers will be meeting somebody for the first time under those circumstances. So an officer can't be held accountable to know what he doesn't know or couldn't know. But if he's had an encounter with that person in the past, then that should be considered as well.
Understanding the new law as it relates to the actions of peace officers in use of force situations is one thing. Having a perspective on how DAs look at cases in the context of these changes is another.
I'm going to use the necessary standard, and I'm going to ask, was the use of force necessary in this situation given everything the officer knew? I'm going to use the objectively reasonable standard. It's a common sense standard, but we're going to have to use that standard and look at the use of force and consider the legality of that particular action.
When the decision is made that if a shooting was justified or not, I can't do it based on what the public wants. I have to do based what the law is.
That what I want to say to police officers is be able and ready to articulate what you did and why. And that I think is going to help everybody sort of when we look at it in retrospect, it helps us understand what the real situation was at that moment.
One of the things that hasn't changed is that law enforcement officers still have a duty to protect the public. They want to do the right thing for the right reason. They're engaged on a constant basis with public safety and justice. It's why they put on the uniform.
California Post and the group of experts who worked on this are hopeful that this program has provided clear, straightforward answers to some of the questions that have arisen since this law was passed. Law enforcement officers are encouraged to contact their local district attorneys for their professional perspective. Additional resources are also available on the Post website.
Post is always there to make sure that they receive the proper training. They can always rely on their training. Post has a number of different resources, either on our website or through a simple phone call to Post to help them further their mission. And I would like to just thank them for everything that they do day in and day out.
And we'll now be going back to the PowerPoint with Director Aguilar.
Okay. Mr. Murillo, actually, if we can start preparing the other video, while I just give some brief remarks. As we saw in that Post video, I know there were a lot of key concepts discussing it, and it is important to recognize that use of force encounters, they deserve a lot of scrutiny, but they are heavily regulated by not only our Constitution, but also these important standards that are further codified in the state law and interpreted by the Supreme Court rulings, various of them. There was one particular case that was referenced multiple times there, and it's the Graham v. Connor, which discusses the objectively reasonable standard. We felt that it was important to ground our audience a little bit more on that case and to have a further illustration of what the objectively reasonable standard means as it relates to use of force encounters. The other important takeaway there is, again, these state laws, and they're providing guidance. There's further guidance in the Berkeley Police Department policy, which we'll discuss after we review these further resources. So if you can, Mr. Murillo, now cue up the FLETC talks. And FLETC stands for the Federal Law Enforcement Training Center. And they have bite-sized videos on important and relevant case law and principles regarding policing. And this one particularly is on Graham v. Connor, which discuss, again, the objectively reasonable standard. So we'll play that, have a little discussion, and then look at the Berkeley Police Department's Transparency Hub.
How will I be judged if someone sues me for using excessive force? That's a fair question for a student at the Federal Law Enforcement Training Centers. Hi, my name is Tim Miller. I'm an instructor at the Legal Division for the Center at Glencoe, Georgia. The leading case on use of force is the 1989 Supreme Court decision in Graham versus Connor. The court stated that all claims that law enforcement officers have used excessive force, deadly or not, in the course of an arrest, investigatory stop, or other seizure of a free citizen should be analyzed under the Fourth Amendment and its objective reasonableness standard. So what happened? Mr. Graham was actually a good guy. Unfortunately, he was also a diabetic. And feeling the onset of an insulin reaction one day, he called his friend Barry and asked for a ride to a convenience store. He hoped to buy some orange juice and thought that the sugar in the juice would counteract the reaction. After the two men arrived at the store, Graham got out of the car and hastily went inside. But the checkout line was too long. Mr. Graham turned around and hastily returned to the car. In his diabetic state, he probably didn't think to ask to jump to the head of the line. Back inside the car, he told Barry to drive to another friend's house. Maybe the friend would have some juice. Waiting and watching outside the store was Officer Connor. Officer Connor had watched Mr. Graham hastily enter and then leave the store. Connor suspected something was amiss. He followed the two men for a block or so and then activated his overhead lights, signaling for them to stop. Beside the road, Barry tried to explain that Graham was just having a sugar reaction, but Connor was not convinced. Connor told the two men to wait at the car. He then directed another officer to return to the store to determine what happened. Well, things got worse from that point. Graham got out of the car. He ran around the car 2 times, sat on the curb, and momentarily passed out. Backup officers arrived. Mr. Graham was handcuffed, thrown into the back seat of a police car. All this time, Barry and Graham, after he regained consciousness, tried to explain that his friend was just having an insulin reaction, but their pleas had no effect. Then Connor received the report from the officer who returned to the store. Nothing was amiss, and Mr. Graham sued the officers. So how should Officer Connor and these other officers be judged? On the one hand, Mr. Graham was an innocent man. On the other, the officers did not know that at the time. The Supreme Court stated that Connor and the other officers should be judged under the Fourth Amendment's objective reasonableness test. That test could be boiled down to 3 questions. First, what did the officer do, or what was the force he used? Second, what were the facts confronting the officer at the time he used force? And second, could a reasonable officer believe that what the officer did fell within the range of reasonableness after applying the facts to the Graham and other factors for using force? Note that the perspective that counts is the reasonable officers, which is obviously the court looking at the facts through the lens of this hypothetical officer. The point being, the subjective beliefs of the actual officer, whether good or bad, are not relevant. Officer Connor may have honestly believed that Mr. Graham was a shoplifter. However, the court's objective test asks what a reasonable officer could believe. Reasonable force is from the perspective of a reasonable officer on the scene. This reasonable officer considers the totality of the facts and circumstances confronting the officer at the time. The only caveat on what can be considered is the no 20/20 hindsight rule, something that was not reasonably known when the officers stopped Mr. Graham and placed in handcuffs was the report from the officer who returned to the store. Nothing was amiss, but to consider that report would be judging Connor and the other officers by hindsight. The no 20/20 hindsight rule, well, it probably worked to Officer Connor's favor in this case. But what if Officer Connor had learned while writing a use of force report that a suspect had a violent criminal history? Whether force is reasonable or not depends on the facts confronting the officer at the time. So, could a reasonable officer believe that stopping Mr. Graham, handcuffing him, and forcing him into the back of a police car was objectively reasonable? The Supreme Court stated that was the relevant question. What follows are some facts and circumstances that could help a court make that decision. They are for illustrative purposes, and not all of them are in the Graham decision. For example, Officer Connor might write in his use of force report, "I saw Mr. Graham run into the store. The door had barely closed to the convenience store before I saw him open it and run back out to Mr. Barry's car and get into the car. I heard the tire screech as the driver sped away at a high rate of speed." Well, would that be enough to stop the two men? The Supreme Court's decision in Terry versus Ohio states that an officer may conduct a temporary investigative detention based on reasonable suspicion that criminal activity is afoot. An officer's training and experience is also relevant in making that decision. Connor might add, based on what I saw and my department receiving several complaints of shoplifting from this store over the past several weeks, I activated my overhead lights and stopped the car. Connor would be admitting to effecting a Fourth Amendment seizure, but a seizure is reasonable when the officer can point to specific articulable facts that criminal activity is afoot. It should be obvious by now that the officer must help the court visualize what happened. Using good action verbs in a report, what you saw, said, or heard makes that visualization possible. Connor might write, after Barry stopped, I walked to his car. Now, walked is a good action verb. The listener can visualize or see Connor walking. The report might continue, I told both men to stay in their car. I ordered another officer to go back to the convenience store and ask what happened. Next, I saw Mr. Graham get out of the car. Graham opened the passenger door. He ran around the car 2 times, sat down on the curb, and fell over as if he had passed out. Officers can make objective opinions. Now, objective opinions are supported by facts. Connor might add, it was my opinion at the time that Mr. Graham was under the influence of alcohol. I make that opinion based upon my years of experience with intoxicated people. They are generally irrational. Graham was not rational. He ran around a car 2 times after I, a police officer, told him to wait inside. Traffic was on the road. Then he sat on the curb and fell over as if he had passed out. To further support his opinion of intoxication, Connor might add, I saw that Graham's eyes were glassy. His speech was slurred. His breath smelled sweet, as if he had been drinking alcoholic beverages. Incidentally, a diabetic's breath may also smell sweet. Connor might explain why intoxication is so relevant. Someone who's not thinking rationally could have stepped out into the traffic and caused an accident, he might state. Moreover, people under the influence of alcohol or narcotics, they're less likely to obey an officer's commands and more likely to be assaultive. Facts paint the picture. Facts allow the court to picture what happened and then make an objective decision. But mere conclusions make someone ask how or why. An example of a mere opinion might be simply stating, Graham was non-compliant. How was he non-compliant? Cop talk creates the same confusion as mere conclusions. Consider, he made a furtive movement. How does someone make a furtive movement? And pre-assault indicator, what's a pre-assault indicator? Other words of caution might be, stay clear of this, stay clear of fuzzy words, like he indicated, suggested, or implied something. How? How did he suggest? How do we imply that? Reports should state what the officer saw, heard, and said. Good fact articulation is not easy. It also takes time. What's more, officers may experience tunnel vision, auditory exclusion, memory loss, but they should paint the picture with the sights and sounds that they remember. While it may be impossible to recall exactly what someone said, the officer may still remember, he screamed at me and clenched his fist like a boxer. The Supreme Court stated, the test for reasonableness under the Fourth Amendment is not capable of precise definition or mechanical application. In short, there are no perfect answers. The perfect answer in Graham's case might have been for Officer Connor to walk inside the convenience store and escort Mr. Graham to the head of the line. But that would require Connor to know all the facts. It would be judging him by hindsight. Allowance must also be made for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Connor made a decision after Graham got out of the car. Obviously, there were other options. And while hindsight may prove one option better than another, what matters is whether the option chosen fell within the range of reasonableness based on the facts confronting the officer at the time. Reasonable force is a balancing test. The facts confronting the officer at the time are applied to the Graham and other factors for using force. The Graham factors are reasons for using force. They act like a checklist of possible justifications for using force. They are not exhaustive and not all of them are maybe apply in every particular case. The Graham factors are the severity of the crime, the immediacy of the threat, and whether the suspect was actively resisting or trying to evade an arrest or other lawful seizure by flight. The severity of the crime generally refers to the underlying reason for seizing someone in the first place. Officer Connor appeared to be acting under a reasonable suspicion that Graham stole something from the convenience store. While that suspicion proved incorrect, the question is whether it was reasonable at the time. Arrests and investigative detentions are traditional governmental reasons for seizing people. It could also be reasonable to seize someone who is not suspected of any wrongdoing. Reasonable force can be used to control the movements of a passenger during a traffic stop. It may be used to detain someone in or around a home while executing a warrant for contraband. The operative word for any type of seizure is reasonableness, which always depends on the facts. Let's skip immediacy of the threat for a moment and go to resistance and flight. Resisting a lawful seizure affects several governmental interests. It may prevent the officer from executing a warrant, or in Officer Connor's situation, prevent him from completing his investigation. Remember, too, that Connor told Graham to stay in the car, and that Graham arguably resisted that order by getting out. He ran around the car, sat down on the curb. Traffic was on the road. He could have caused an accident or injured others. Now let's look at threat. The Graham factors cannot be considered in a vacuum. The nature of Graham's resistance could also support a threat to the safety of the officer or others. Threat is generally considered the most important governmental interest for using force. What's more, attempting to evade a lawful seizure by flight causes some of the same concerns as resistance and may also pose a serious threat. Two subsequent Supreme Court cases called Scott versus Harris and Plumhoff v. Reichert involve speeders. They fled when officers signaled them to pull over for traffic violations, and in doing so caused a significant threat to everyone on the road. The lower courts would go on to add other factors. For example, what was the known violent criminal history of the suspect? Another might be the suspect's size, height, weight, and condition compared to that of the officer. And the presence of innocent bystanders is also a factor to consider. But while the courts have listed other factors to consider, they are generally a subset of what is considered the most important Graham factor, immediacy of the threat. In Graham, the offense at issue was possible shoplifting, and the initial intrusion on Mr. Graham's liberty was only sitting in a car. As the encounter developed, however, the intrusion on his liberty became greater. But didn't the governmental interest for more force also become greater? Again, Officer Connor told the men to wait at the car. Graham resisted that order by getting out. Add that to his irrational behavior and the possibility he might get out on the road and cause an accident. Maybe I should ask you, could a reasonable officer believe that what the officers did, the force they used, fell within the range of reasonableness after applying the facts confronting them at the time to the Graham and other factors for using force? This has been FLETC Talks. I'm Tim Miller, and thank you for listening.
Okay, Mr. Murillo, if you could start queuing up the Transparency Hub, I'll just give some brief remarks on this. We have grounded you so far on two very important guiding principles and policies, that is under the state law, AB 392, and particularly the one of the pivotal use of force cases on Graham v. Connor. And both of them really emphasize the reasonableness of officers' actions, and also do understand and emphasize that officers aren't perfect, but they must be reasonable. When we receive allegations of police misconduct, we closely scrutinize the events. We review several exhibits of information and of evidence, whether it be body-worn camera footage, whether it be the radio transmission, and the communications between the officers, the police reports, and we're going to also have conversations and interviews with the officers to ensure that they are articulating their actions and the use of force that they may have utilized. And we then collectively look at the evidence and try to ascertain whether by preponderance of the evidence, or as the investigator mentioned, more likely than not, there was a violation of these use of force principles, whether they properly de-escalated the situation, whether they utilized the proportionate amount of force required to either effect an arrest or um, to um, ensure that the subject and or the community members and the officers were safe during that encounter. So these are the specific mechanics of what our investigations look like, and they're grounded on these guiding principles. Before we specifically look at the use of force policy, we're gonna change up the pace a little bit, and we're going to do an overview about on the Transparency Hub. Our policy analyst, Mr. Murillo, is going to share his screen and let us know how to access the Transparency Hub, and particularly how to look at some of the data regarding use of force encounters.
Thank you, Director. As the Director mentioned, Berkeley PD does have a police transparency hub where they make a lot of their data from stop data, call for service, and use of force is relevant. Today's conversation available to members of the public. You could find it using the link up here. And just for the record, we acknowledge that there was an error in the link earlier when we sent out this invitation, but we just wanted to provide that for you. But anyways, on this portal, you can find the use of force. All the data is publicly available, as well with the different definitions for how force is categorized. It starts from level 1, which involves anything from a grab, control, use of leverage against an individual, all the way up to level 4, which applies when an officer uses a firearm or when there is an in custody death. So all these definitions, or every instance of use of force, is categorized under one of these 4 levels. If we go further down, and one of the nice tools that the Berkeley Police Department offers the community is that we could actively analyze the use of force data, and any member of the public could view these reports. The Transparency Hub provides us, again, as I mentioned, the definition of the different levels of force, as well with the summary statistics for the instances of force. For example, we know that since last year, and in terms of year to date, there's been a total of 195 instances of uses of force involving 212 subjects, and just a general breakdown in terms of the different levels used for each category. If we go specifically to each section, we could see that, for example, in this case, the use of force level was a level 1 force. And beyond these graphics that show you where in the city each instance happened, the BPD does make their use of force data in a raw format available to the public, which allows for an independent analysis of every instance. With that said, I'll take it back to the director to bring us back to the PowerPoint.
If I may, our Mr. Murillo, if we could just stay here. If we could look at some of the highlighted incidents of even today or yesterday, rather, on August 18th, and the level of detail, I think it's important for community members to understand and really put into a concrete understanding of these principles we just talked about. So there was a level 3 of, if you could do the first one, the level 3 on August 18th, incident number 3522. The primary reason for the use of force was fleeing. And I think that really contextualizes what we have been talking about here. If we were to receive a complaint from that initiated from that encounter, we would ask for the body worn camera footage. We would collect the police reports, again, the radio transmission, different exhibits, and try to analyze whether that level of force was appropriate for that fleeing situation. So again, this is a level of transparency that is helpful to really communicate to the members of Berkeley and our visitors how officers are making these decisions when they have to arrest and or detain individuals. If you can go down, Mr. Murillo, just to make sure that we're providing them a full overview of. this is an important element of it too. It gives you a summary data on the demographics of how force is being experienced by different members of the community based on their demographic categories. So again, it continues our conversation about fair and impartial policing, about how to raise awareness about police encounters, and about our complaints process, and how individuals can ensure that they're getting a venue to have a redress for their grievances that may come out of these police encounters. And if you could just scroll all the way down, just make sure that okay. And now the policy itself, Mr. Murillo, if you can just go to it before I open up my the PowerPoint again. Okay. I really want to just emphasize how the policy opens up in the concept of sanctity of life. And it indicates that the Berkeley Police Department's highest priority is safeguarding the life, dignity, and liberty of all persons. Officers shall demonstrate this principle in their daily interactions with community they are sworn to protect and serve. The department is committed to accomplishing this mission with respect and minimal reliance on the use of force by using rapport building, communication, crisis intervention, and de-escalation tactics before resorting to force. Officers must respect the sanctity of all human life, act in all possible respects to preserve human life, do everything possible to avoid unnecessary uses of force, and minimize the force that is used while still protecting themselves and the public. So I just want to emphasize how important it is to codify the sanctity of life principle in a use of force policy, and certainly to start the policy itself by communicating to the members of the police department and also the community at large that the highest priority is safeguarding the life, dignity, and liberty of all persons. I think that's a good starting point for any police department, and certainly for the police department and our policies here. And if you can stop sharing, I'll take over again and share my screen. One minute. I am going to share. Okay. And am I sharing the right slide, Mr. Murillo?
If we could go forward to slide 12. Okay. So again, BPD policy 300, as well as the rest of the law enforcement manual for the Berkeley Police Department, is actually publicly available. The Berkeley PD is required to post all policy and training materials in order to comply with California Senate Bill 978, which was passed in 2018 and went into effect in 2019. Senate Bill 978 amended California Government Code Section 6254.21, and essentially requires all law enforcement agencies to post their policies and training procedures online, as well as provide details on officer training, including topics and duration, in addition to just generally increasing public access to these records with the purpose of increasing transparency and accountability in the state of California. For Berkeley PD's manual, you can follow the link on the screen, and I'll take you to the current law enforcement manual, as well as their training materials, which are publicly available. And with that, I will hand it back to Director Aguilar.
Thank you, Mr. Murillo. And we're going to make one last stop before we get into our incident review, and then have a conversation and a reflection on a actual use of force encounter. But like I mentioned earlier at the onset of this presentation, the policy itself, it's 17 pages. It's a lot of important principles discussed in there. We broke down these forums so we can talk about different concepts within use of force. And today's forum session is on proportionality and de-escalation. And specifically in the use of force policy of the Berkeley Police Department, there is a conversation about what proportionality means as it relates to force. And that is in BPD policy section 300.3.1, factors used to determine the reasonableness, necessity, and proportionality of force. So this is a verbatim review of this section, and we're going to do these two sections before we go into our incident review. So when determining as in accordance to the Berkeley Police Department policy, when determining whether to apply force and evaluating whether an officer has reasonable, objective, necessary, and proportional force, a number of factors should be taken into consideration as time and circumstances permit. These factors include, but are not limited to, the apparent immediacy and severity of the threat to officers or others. And that language should be familiar to you now. We heard it in the Graham v. Connor. We've also heard it in the penal code, the amended penal code that we heard in the post video earlier today. The conduct of the individual being confronted as reasonably perceived by the officer at the time. Again, we are in an era where there is a lot of community engagement as it relates to police encounters. And we have a lot of community members that may perceive an encounter in one particular lens. But when we're reviewing use of force encounters, we have to consider whether the event how the event was perceived by the officer at that time and whether that was reasonable. So we also heard in the Graham v. Connor other factors like the officer and the subject factors to include the age, size, relative strength, skill level, injuries, and sustained level of exhaustion, fatigue, the number of officers available versus subjects. Again, all of these factors are relevant to ensuring that the officer is making a reasonable assessment of the situation and taking the proportional or utilizing the proportional amount of force necessary in that encounter. The conduct of the involved officer, the effects of drugs or alcohol, the individual's apparent mental state or capacity, the individual's apparent ability to understand and comply with officer commands, proximity of weapons or dangerous improvised devices, the degree to which the subject has been effectively restrained and his her ability to resist despite being restrained, the availability of other reasonable and feasible options and their possible effectiveness. Now, keep that in mind in the event that we're going to show in the police encounter that we're going to show in that particular jurisdiction, the officers were equipped with tasers. In the city of Berkeley, our officers are not equipped with tasers, so that's not an option that they will use in a force encounter. Seriousness of the suspected offense or reason for contact with the individual, training and experience of the officer. We heard that in the Graham v. Connor discussion in the video we reviewed tonight. The potential for injury to officers, suspects, bystanders, and others, whether the person appears to be resistant, attempted to evade arrest by flight, or is attacking the officer, the risk and reasonably foreseeable consequences of escape, the apparent need for immediate control of the subject or a prompt resolution of the situation, whether the conduct of the individual being confronted no longer reasonably appears to pose an imminent threat to the officer or others, prior contacts with the subject or awareness of a propensity for violence. Again, we heard about 2020 hindsight, but in this particular factor, we're having a consideration about the prior contacts that the prior contacts with the subject and awareness of the propensity for violence. Again, that's something that we as an office would review and ask officers about when we receive an allegation on use of force and any other exigent circumstances. Now, de-escalation could be a very nebulous concept, and the intent of this section of the policy is to really provide concrete guidance to the officers about what de-escalation can and should look like. And this is also important for community members to understand when we're having discussions about what the expectations of our officers are, we should be grounded on what the policy says as it relates to de-escalation. So again, under BPD policy 300, particularly 300.3.4, we discussed de-escalation tactics. So de-escalation tactics under the BPD policy and techniques are actions used by officers which seek to minimize the need to use force during an incident. Such tactics and techniques may increase the likelihood of voluntary compliance when employed and shall be used when it is safe to do so. De-escalation tactics emphasize slowing an incident down to allow time, distance, and flexibility for the situation to resolve. Officers shall continually assess the dynamics of the situation and modulate their response and actions appropriately. Officers may be justified in using force at one moment, but not justified in using force the next moment due to a change in dynamics. Again, it's very important to recognize that this section of the policy emphasizes the dynamic nature of an encounter, and particularly when officers are potentially going to use force. It may be reasonable in one incident of that encounter, but it may no longer be incident depending on how the situation has changed throughout the interaction. The application of these tactics is intended to increase the potential for resolution with a minimal reliance on the use of force or without using force at all. It is not the case that all encounters can be resolved without force. That is an unfortunate reality in society, that some encounters do require a physical use of force, and the law recognizes this and trust police officers with the ability to make and utilize this physical use of force when required and necessary. If immediate action is not necessary, an officer shall attempt to use verbal de-escalation techniques. When available and practicable, a crisis intervention team or CIT officer, a crisis negotiator, or Berkeley mental health mobile crisis team member shall be called upon as a resource. Another resource that community members should know is the specialized care unit that it is currently being deployed, and the Police Accountability Board has also been exploring in conjunction with the other city stakeholders and community members how we can utilize the specialized care unit services more to reduce the need and the propensity for use of force encounters when not necessary. Officers shall gather information about the incident, assess the risk, assemble resources, attempt to slow momentum, and communicate and coordinate a response. In their interaction with subject, officers should use advisements, warnings, verbal persuasion, and other tactics and alternatives to any levels of force. Officers should move to a position that is tactically more secure or allows them greater distance to consider or deploy a greater variety of force options. Again, the officers' role in de-escalation is to make sure that they're being dynamic as well, and that they're putting themselves in a tactical position that allows more distance and time to deploy a greater variety of force options. Now, particularly, these are some of the techniques that the de-escalation tactics section has. So de-escalation techniques may include verbal persuasion, warnings, and tactical de-escalation techniques such as slowing down the pace of an incident, waiting out suspects, creating distance, and thus the reactionary gap between the officer and the threat, and requesting additional resources, specialized units, mental health care providers, negotiators, etc., to resolve the incident. Officers should recognize that they may withdraw to a position that is tactically advantageous or allows them greater distance to de-escalate a situation. Officers should consider a variety of options, including lesser force or no force options. Officers should attempt to understand and consider possible reasons why a subject may be non-compliant or resistant arrest. A subject may not be capable of understanding the situation because of a medical condition, mental, physical or hearing impairment, language barrier, drug interaction, or emotional crisis and have no criminal intent. These situations may not make the subject any less dangerous, but understanding the subject situation may enable officers to calm the subject and allow the officer to use de-escalation techniques while maintaining public and officer safety. Officers should continue de-escalation techniques when feasible and appropriate and take as much time as reasonably necessary to resolve the incident in an effort to avoid and or minimize the use of force. When an officer recognizes that mental illnesses, post-traumatic stress disorder, alcohol and or drug addictions or other health issues are causing an individual to behave erratically, the officer shall, when feasible and appropriate, try to de-escalate the situation using de-escalation and or crisis intervention techniques. Establishing communication with non-compliant subjects is often most effective when officers establish rapport, use the proper voice intonation, ask questions, and provide advice to diffuse conflict and achieve voluntary compliance before resorting to force options. The officer's physical actions may also de-escalate a potentially volatile, violent situation, exhibiting relaxed body language. So in these two sections we just read, and we were very purposeful about reading them verbatim. We want to make sure that the community members are exposed to the actual language and the policies, but also see how robust they are, but also try to engage with the community to see if there are any gaps within this policy or these sections that we as a community would like to see in these policies. Again, I mentioned that the policy itself has a provision for the Police Accountability Board and the police department to review it annually. So as part of our support to the board, the Police Accountability Board has asked the Office of Director of Police Accountability to engage in an initial review of this policy. And we are, as an office, conducting a review ourselves. But we also wanted to invite the community through these forums to provide feedback on these particular concepts and to see if there's anything that the community would like to see improved in how the policy is currently structured. So that being said, I think we provided a good grounding for us to be able to have a review of a use of force encounter. Again, I want to highlight a few things. This is graphic in nature. There is a physical force, particularly there was a use of electronic control device or a taser. And also, if you look at the date, this happened on June 5th, 2020. It was about a week removed from the George Floyd incident, and it has some eerily similar elements to that encounter. And we want to just provide that graphic content warning. This video is currently posted, the one we're particularly showing you, on a YouTube site, and this summary it was taken and adapted to be in past tense because it was written in real time, the description, so we just modified it for past tense purposes. But another disclaimer I'd like to provide to you: prior to my arrival in the city of Berkeley, I had served in other jurisdictions around the country doing this work of civilian oversight of law enforcement. One of those jurisdictions was Fairfax County. I was a resident of Fairfax County when this incident encounter occurred. And I was also sitting at the time on our police civilian review panel. We did not receive a complaint for review of this incident. We were aware of it. It did make the news. We did have a hybrid system in Fairfax County, and it had an independent police auditor whose stated mandate was to review use of force encounters, but particularly to review the internal affairs investigation on use of force encounters. And our independent police auditor did review the internal affairs investigation of this encounter. I don't want to give too much of it away. I'll give some information after we review it. I'll read the summary real quick for you, just to give you a preview of what you're going to see. It's a relatively short video, and then we'll have some reflection questions and open it up to public comment. So again, this is Fairfax County, Virginia. A Fairfax County Police Department officer faced 3 charges of assault and battery related to an on-duty incident Friday. Again, this relating to 2020. Fairfax County officer Tyler Timberlake was arrested June 6th after body cam showed him striking a man with a stun gun and then or taser, and then getting on top of him along with the officer wearing the body camera. Once Timberlake was on top of the man, he pressed a stun gun into the back of his neck and fired again. Fairfax County Police Chief, he was the chief at the time, Edwin Rosler Jr. said someone called police about a man walking down the street shouting that he needed oxygen. An officer who responded before Timberlake tried to de-escalate the situation, the police chief said, adding that it's unclear why Timberlake used a stun gun. As part of the investigation into the incident, the other 3 officers involved were placed on administrative leave. The man was treated at a hospital and released, the chief said. Timberlake faced up to 36 months of incarceration. Okay, the YouTube link is provided there. Mr. Murillo, do you have it queued up so I can stop sharing and you play it for us?
Yes.
Okay. Again, graphic content warning. If you need to step away, please do so and join us back in 5 minutes or so.
Did you call, sir? Did you call? No? Okay. Did you hear anybody? There's apparently somebody was saying they needed.
Man.
Hey, how you doing?
How you doing?
Good.
Man.
Nice to meet you. Somebody said they needed oxygen. That was you?
Good.
Okay, we want to go over to the fire department.
What?
Yeah.
Hey,
You don't need oxygen?
Why need oxygen? Why you need oxygen? Why you need oxygen? Why you need oxygen? Why you need oxygen?
Still having a problem. I'm out with one with the fire department. He's walking around in the middle of the street, rambling. Sir! Sir!
10-4-13-27.
Are you doing okay? Do you mind stepping out of the road? Maybe.
Yeah.
No? What can I do for you?
You can help, man.
Well, okay, I'm here to help you. So just tell me what you need. You want a detox?
Yeah.
So you want to go to the hospital?
Yeah.
Okay.
Alright.
Stop.
Or you want to go to the hospital?
Stop.
All right.
Stop.
I understand.
Stop. I just want to say that. Stop.
They're going to take you to detox.
I guess he doesn't want to go detox.
I don't know, man. Sir! Devontae, right?
Yeah.
You want to go to detox?
Yes.
Alright, you got to get in the ambulance with them if you want to go to detox.
No. Speak to Didi.
Hey, Jenna, what's the address my cat said?
So you don't want to go to detox?
No.
Where do you want to go? Would you mind stepping out of the road for me?
No, goodbye, Goodbye.
What's up?
Goodbye. Sabaya Pittman need help. Sabaya Pittman need help.
Where's he?
Sabaya Pittman need help. Sabaya Pittman need help.
Who's Sabaya Pittman?
Sabaya Pittman need help. Sabaya Pittman need help. Sabaya Pittman need help.
So do you not want to go to the hospital?
Sabaya Pittman need help. 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 Sabaya Pittman.
Who's Sabaya Pittman?
Sabaya Pittman.
He's ready to come find look over from
Sabaya Pittman need help.
Who's that?
Sabaya Pittman need help bad. Sabaya Pittman need help bad.
You can look out for 2 motorcycles racing in the neighborhood. No further in the lookout 1329.
We take you to the hospital?
Yeah.
You'll go with us to the hospital?
Yeah.
You get in the back of the ambulance?
Yeah.
Come on.
So you're going to get in the back of the ambulance, right? No?
Get on the ground, Anthony.
Is he wanted?
Roll over. Anthony, relax.
Didi.
Anthony, relax.
Didi.
Anthony, give me your arm.
Didi.
Anthony.
Two of them up.
arm. You're good to get up. You're good to get up. I got you. Got the arm.
No.
Got him. Come on, man. Calm down. Calm down. You got cuffs? You got cuffs?
Drop that first there.
Arms under here under
We're at Fordson and Fordson.
Jackson under your belly. I got him, Jackson. Go ahead, let's go test him.
I got his shoulder there.
I got him right here. You got him right here? No, coming up.
Didi.
Got it.
Didi.
Got him.
Didi, I can't breathe, Didi.
All right, get
Didi, I
it. Nobody on
can't breathe, Didi.
him?
Didi, I can't breathe, Didi.
No, nobody's on your neck.
Didi.
Nobody's on your neck, buddy.
Hey, we're gonna get you rolled over. We're gonna get you rolled over.
Didi. Didi, I can't breathe. Didi, I can't breathe, Didi. Didi, I can't breathe, Didi.
Hey, we're gonna roll you over. Are you good?
Didi, I can't breathe, Didi. Didi, I can't breathe, Didi.
We got you on your side,
Didi, I
man.
can't breathe, Didi. Didi, I can't breathe, Didi. 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 Hey, Didi. Hey, Didi. Didi, I'll tell you now, Didi. I got it. I'll take it. Didi, Didi. There you go.
Hey, you're good. Hey, breathe. 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 Calm down. You got it?
Yellow span. Yellow span.
Hey, just breathe, man.
Yellow span.
I don't know what Alice span is.
Yellow span. Yellow span. Yellow span. Yellow span. Yellow span. Yellow span. Yellow span right now. I said yellow span right now. Yellow span right now. Yellow span right now. Yellow span. Yellow span. Yellow. Yellow. Yellow span. Yellow span. Yellow.
Okay. Allow you to take a breath. We understand the graphic nature of that content we just displayed. We did conscientiously choose to utilize the use of force encounter that we can have a review of, so we can have a conversation about what these principles look like and should look like, these de-escalation and proportionality. So we again recognize that it might have been graphic for our viewers, and then we hope that we haven't disturbed you. We do respect if you need to take some time as you return back to this conversation, to this forum. But we do want to proceed with some general reflections. And if I may, real quick, I'm just going to share my screen again. Okay. Where are we? Are we in
Slide 21.
Are you reviewing the
And then if you could transition to the PowerPoint.
Are you reviewing the PowerPoint or my notes?
Your notes.
Okay, let me swap it out again. Okay, which are you reviewing the PowerPoint at this time?
We just need you to put into presenter mode.
Yeah. Okay.
There we go.
All right. So again, initial thoughts at anybody may have in this encounter, and upon initial review, maybe what happened. It seemed like the initial officer and the EMTs were having a conversation with the individual, and then within minutes, this additional officer came to the scene, and within a minute of his arrival, he utilized his taser. So that I believe was the initial reaction, generally speaking, of anybody reviewing this encounter. What exactly happened? Why did it seem to go from that point to that point so quickly without background? Again, our analysis on use of force, it should be to try to understand, was it reasonable? What did the officer know? What was being, what was happening in that particular event at that time? Was it a proportional response? Is potentially another question that we should be asking ourselves. And what do we think about the other officers' responses? There is now, since George Floyd, there's a lot of um, attention on what other officers are doing on the scene, are they in their duty to intervene at the scene if an officer appears to be utilizing excessive force at the time. And what do you think are some suitable repercussions for the officer who discharged their taser? Uh, in throughout this case, again, we mentioned in the brief description that the officer was charged. There has been several years since. He's actually went through a jury trial and he was acquitted. The officer, ironically, as a way of transitioning from that department, went on to the Minnesota Police Department, and he was then shortly after removed, partly because of this encounter and whether the chief in Minnesota believed that he utilized what they deemed to be proportional use of force, and what impact that would have to that community, considering the event of the murder of George Floyd. So there are several, I think, elements that I think we can analyze in this event. We saw an individual whose perhaps the state of mind seemed to be altered one way or another. There were officers, at least the initial officer was trying to have a conversation with the individual. He appeared to be incoherent, but he was getting some sort of responses from the individual. He was in the middle of the street, so potentially there's the analysis of whether he was putting himself or others in danger. However, we would also look, if we're investigating this, whether there was any immediate danger, considering that the EMTs were there and appear to be somewhat close and off the street, some partly, although the officer that drove in, he wasn't, he didn't appear to have his side of the street obstructed. It was also during the day. Again, all these different elements and factors would be something that we would consider as an investigative body. The officers who utilized the force on the scene, particularly Officer Timberlake, who utilized the taser, would also need to ensure that he can articulate why he utilized the force. Now, he did in the trial indicate that it was a case of mistaken identity. If you slow down the video, it appears that he utilized a name, and that was the name of the individual he had prior contact with, which he knew to be somebody that might have been somebody that might have had violent propensities. So again, these are things that the courts we consider, that we would ask questions about when we're doing our analysis on the use of force. I think one of the other elements, again, is just to ground ourselves in the ground factors, are the severity of the crime, the immediacy of the threat, the active resistance of the arrest, whether there was an attempt to evade or arrest by flight. So at this time, we want to start transitioning over to see if there's any in interest in providing some public commentary on either the video we just reviewed and or any of the presentation of this forum tonight. I also wanted to open it up to our policy analysts and or any of our staff members here to see if they want to provide any remarks regarding the video and or our presentation tonight before we close it off.
I'll just remind members of the public and those who will watch our video later on, if they couldn't make it tonight, that we will be posting these materials. And if you have questions, our office is more than welcome to answer those questions as they may come. we answer. Again, there'll be 2 additional sessions, which we have noticed, and we'll send out a reminder. But just to put that on everyone's radar that we will be sharing these materials in case there's any questions that may not come up now, but come up later once you've reviewed the material again.
Okay. And again, and I'll emphasize again that this use of force discussion in this forum is intended to guide and provide some materials for the Police Accountability Board, who will be meeting later on with the police department and having their annual discussion on use of force. So any feedback that you're interested in providing us will certainly be welcome. Our office is doing an independent review of it, and will also incorporate any of the feedback that's been provided by community members.
Okay. So at this point, we could transition if there's any of our viewers that would like to provide public comment or share their reflection with us. Please use the raise hand icon and we'll be happy to grant you permission to speak. Again, using the raise hand icon and we'll be happy to grant you permission to speak.
Okay, I do see a question on the Q&A. I don't know that we have a particular a statistic, but it's certainly a question within our reach. And again, we will plug in the Transparency Hub. These are the type of questions we mentioned that if we don't have an immediate response, we'll certainly get back to community members. I'll read the question. It's what percentage of total calls for service result in a use of force incident? I'm assuming we're talking about in the city of Berkeley, not generally. But Mr. Murillo, do we have that immediate statistic, or is that something we'll get back to?
We'll have to get back to that just for that data pool. But
Okay.
we appreciate the question and we'll make that available as soon as we can.
Yeah. And generally speaking, I would say use of force are not a utilized in the majority of encounters. So I would certainly say it's definitely not a majority. It is a relative, generally speaking, a relatively low number, but we can get that specific number and that percentage for you. And thank you for that great question. I think I also want to highlight in the Transparency Hub, you can see in the page we were in on the use of force page, there is a recognition that the use of force policy has recently changed, and the reporting has also changed. And we'll have a more thorough discussion on the reporting requirements in one of our subsequent sessions, but that it's related to your question on the total calls for service and how they're reported out, and also the particular levels of force. We talked about level 1, 2, 3, and 4, and how those are categorized. Okay.
And I currently don't see any additional hands raised. But as we noted earlier, we're more than happy to take your questions if they come up after our presentation. And again, we'll be providing additional information.
Okay. Ms. Murillo, do you have the right slides up? Present?
Yes.
Okay. So here's our information, how to get in touch with either me or Mr. Murillo. We are currently located in a temporary office. If you do send mail to us, we can still receive it at that location. Please contact us via phone or email if you want to get in touch with us. We are located right around the corner from there and right above the Ace Hardware store. And we are going to be moving down the street in a few weeks. We'll be providing community members to engage with us and have more conversations. We just want to remind before we close out that the conversation doesn't end here. If you have additional questions or comments after today's forums, please feel free to contact us and reach out to us. Our contact information is provided here, as you see, and we encourage you to stay engaged with the ODPA and the PAB. The PAB is currently on recess. They meet 18 times during the year. The next regular board meeting will be on September 11th. And we have those meetings in a hybrid format in our current temporary location in Milvia. It's 2020 Milvia, Suite 250. Feel free to stop by and or catch us on a Zoom webinar. And we thank you again for your participation tonight and your commitment to police accountability in our community. Have a good night.